Sure. My name is Neal Katyal, and I'm a law partner at Hogan Lovells, where I co-direct our appellate practice, and I'm also a law professor at Georgetown. Sure. I grew up in Chicago. My parents came from India, and I was born a year after they got married. They got married in India, and then they moved to the United States. And grew up there. Like many Indian Americans, I was told there was only one profession, or possibly two, to be a doctor or perhaps a physician. I really internalized that. And I remember being in high school, and someone asked me, "What am I going to be?" And I said, "A doctor." And they said, "Why?" And I said, "Well, you can do a lot of good for the world." And I remember the person saying, "Well, you can do good in other professions like pro bono work." And I said, "What's pro bono?" I had no idea. At the same time in high school, I joined the debate team. I was a shy kid and interested in science, but somehow got into that, and that really changed my life. And from the time I was a sophomore in high school through my senior year in college, I was flying around the country and debating against other people, researching all the time back at home, and then going and using that research in arguments over the weekend across the country. And indeed, one of my big arch rivals was a guy named Tom Goldstein in high school, and there have been many others in high school and college, Lisa Blatt and other people who I come across with a lot of frequency today. So anyway, so I did that. I went to Dartmouth College where I debated, and then to Yale Law School. And I graduated from law school. I applied to clerk and clerked first for Judge Guido Calabresi, who was our dean at the Yale Law School, and had just been appointed to the Second Circuit, and then was lucky enough to get a clerkship with Justice Breyer after that on the Supreme Court. During my clerkship on the Supreme Court, I also went on the teaching market, because teaching has been kind of the passion of my life. And I got a job at Georgetown while I was clerking and thought I was going to do that. And lo and behold, all these kind of things are always random, but I had worked for Al Gore's office one summer. He was the vice president, and his counsel called me up and said, "We're going to nominate someone to be the deputy attorney general, and I think you'll really like this person, and maybe would you like to work for him?" And I said, "What's the deputy attorney general?" I had no idea what the deputy attorney general was. They said, "It's a guy named Eric Holder. He'll be the number 2 person at the department." And so I met him and agreed to work for him. So I built in a 2-year leave to joining the faculty at Georgetown in order to go to the Justice Department. And I thought at the time that was a really good idea. I hadn't ever practiced law in any way, shape, or form. I've always thought it's important that people, the students in law schools, have at least some professors who've had some real-world experience. And so I did that. And I thought I would be doing kind of appellate-y, kind of complicated issues of law. Well, it turned out that, it was a hodgepodge of things, but more than anything, it was 2 things, the national security side and as well the Independent Counsel Act. This was a time when the Monica Lewinsky and Whitewater investigations were ongoing, and Ms. Reno had asked me to look into should the Independent Counsel Act be killed as a policy matter. And so I spent a couple years on that. And a lot of time on national security work, and I got the national security bug, and that's what I love to do. And I remember when I left the Justice Department, I said to myself, the only job I want in law again is to go and be like a national security advisor or something like that. That was really, to me, the end-all and be-all. I had no thought whatsoever about being an appellate litigator at that time. It was the national security policy work that was so fascinating and interesting to me. And in general, it was a pretty closed set of people who worked on those matters, and it was an opportunity there to come in and to do some good. Well, the thing about national security law, and I had taken a course from John Hart Ely in law school. He was visiting at Yale that year about national security in the law, and it's wonderful because you've got really institutional constraints. The courts aren't very good at making law in this area for I think appropriate reasons. They don't have intelligence backgrounds and briefings and the like, but you have this whole tradition of internal executive branch rulemaking on how they're going to approach really difficult questions. I mean, for us, we had, India and Pakistan detonated nuclear weapons, how those sanctions were going to be adopted. We had Pol Pot alive and possibly able to be captured, and what kind of trial we'd bring for him. We had the horrific attacks by bin Laden on our embassies in Africa and the response to that. We had all sorts of really difficult intelligence questions that came through, and to be the National Security Advisor at the Justice Department at that time, which I was a really phenomenal set of experiences, and I just loved it so much. The thought that I would do anything in the appellate realm was not really possible. So when I came to the Justice Department, I didn't have a national security background except for one course taught by John Hart Ely, but that just happened to be the opening at the time that they needed someone for, and I worked a day and night to make myself not just available but good and value added. So that's what I did. And then things changed. I left the Justice Department in November of 2000. Just a little bit after I left, we had a difficult presidential election that was deeply contested. Some of the vice president's folks asked me to be part of that team, and for 36 days and nights, I disappeared from the face of the earth while I worked really with a team of students on that litigation. And that was really my foray back into the world of appellate advocacy. From there, it was obviously a tough thing to work for Vice President Gore during that. And after that, I wasn't sure that appellate law was really my thing. And then we had the tragedy of 9/11. And I remember after 9/11, I was teaching constitutional law that year. I was teaching it at Yale, and my students were always teasing me that I was so deferentialist to the executive branch, and that I generally can't. I wouldn't think anything the president does is unconstitutional, particularly in the national security realm. And I remember that I came into class around November 15th, 2001, and said, you all are always saying that I'm just such a deferentialist to the executive, but here's something that's really blatantly unconstitutional. It's a order by President Bush to set up these military trials at Guantanamo, where he would set up all of the trials, he'd write all the rules, he'd handpick the defendants, he'd handpick the prosecutors, he'd handpick the defense counsel, he was going to handpick the appellate judges, he was going to define the punishments, which he said included the death penalty. He was going to write all the criminal procedure rules for the trial. And then, by the way, the last lines of his order said, the federal courts have no business reviewing what I'm doing on habeas corpus review. Well, I thought that went too far, and I wound up testifying in the Senate a couple weeks later on November 28th, 2001, about that. And then ultimately, Larry Tribe testified a few weeks later, who I know has also been on this interview series. And we decided to do what law professors do, which is write a law review article as fast as we can about why President Bush, what he was doing, was unconstitutional. So we rushed that to print in the Yale Law Journal. And we thought that we were told that these trials were going to happen imminently. Well, we waited and waited. Nothing happened. Nothing happened really for about 2 years when they finally got around to appointing a defense counsel. And I reached out to that defense counsel and said, here's my article. I really do think that these are problematic. And at the time, we had just had our first, child recently, and on our way to our second. I wasn't really sure I wanted to go and throw my hat into the litigation ring, particularly into something that was this controversial and difficult. And there were, respectable people on both sides who had very strong feelings about it. But I also thought to myself that I remembered my days in the Clinton administration in the national security realm, and who does that work? It's really a small subset of people. And for me, I taught constitutional law, and I did national security background, and I had a strong reputation at that time of being, a moderate and a hawk against bin Laden and so on. And I thought to myself, if I don't step up and do this, I'm not really sure who else would that could make the credible case here. I mean, certainly there'll be any number of interest groups that would, but for me, this wasn't ever a matter of ideology. This was a matter of kind of centrist, obvious constitutional principles, and that I didn't think politics or the agendas of various groups should get in the way of the court just seeing what this was, which was a real blatant power grab by the president. So I reached out to the defense counsel, and we ultimately created a test case. We filed it in the district court, and that case ultimately became Hamdan versus Rumsfeld, which was my very first Supreme Court argument. So when I filed the case initially with my amazing co-counsel, Lieutenant Commander Charlie Swift of the U.S. Navy, the JAG Corps, and Perkins Coie in Seattle, because we filed the case in Seattle, I didn't file it in order to be some litigation maven or something like that. I just filed it because I had some thoughts about how to frame up this case in a way that could win. And to do it in a respectful way to the executive. And so that's why I did it. And as the case went on and on, my kind of debate background and my kind of legal training and stuff kicked in, and I thought, well, this is actually kind of fun. But truth be told, the Supreme Court, when they granted cert in the case on November 7th, 2005, between November 7th, 2005, for the next couple weeks, I thought about, and I did try and give the case away to various established Supreme Court litigators, because when I was clerking, saw so many people keep their own case and fall on their face, and that was the last thing I wanted to happen. This issue was really important. And ultimately, I wound up keeping the case. It was a long story. In part, there were conflicts among other people. I had approached Ken Starr, among others. And then Congress did something really unusual. A few days after cert was granted, they decided to try and strip the Supreme Court of the ability to hear the case, something that hadn't happened since the Civil War. And so this case became really huge. And a lot of the law firm practitioners that wanted the case, I was just worried that it was just going to be, another case for them, and I wasn't sure they had the time, particularly now that the case had become so astronomically huge. I mean, there were thousands and thousands of pages of briefs, I think 40 different amicus briefs and the like. And I said to myself, okay, I'm going to do this, but, I'm going to do everything I can. I might fall on my face, but I'm going to do everything I possibly can to do the best job I can. And so I remember I took a legal pad out of paper one night, and I said, who are the people who scare me the most in the country in terms of like the lawyers who could moot me? And I made this list, and I remember it had Elena Kagan on it, and Harold Coe, and Lawrence Tribe, and people like that. And I called them all up and asked them, would you moot me? And it was remarkable. Cross-section of people, politically left and right. Everyone agreed to moot me except for one person, and I had so much respect for this. Charles Freed at Harvard, former Solicitor General, said, Neal, I could tell you that I'm just unavailable on that day and refuse to help you for that reason. But the truth is, I want to be honest with you. I don't want you to win. And so I'm not going to help you. And I thought that was also sweet in his own way, and Charles is wonderful. But I did go around and moot the case. And I remember at my very first moot, was at Harvard, and Larry Tribe, among others, was there. And I remember Larry saying, we were in this huge Ames moot courtroom, it holds like 500 people, and it was me behind this podium and they sitting up high on the bench. And he said, Neal, you sounded a little small at the podium. And, I did. I sounded kind of a little timid and not directing the argument in any way. And I didn't really have presence. I was too focused on my legal notes and, trying to make every possible point the way I used to in debate. And Charlie Swift, my co-counsel, said to me, I have someone I want you to meet, because I think he can help you. And I said, all right, I'm happy to take any advice on this at this point. I'm about to argue this huge Supreme Court case. I'm scared out of my mind. He said, look, this guy can really help you. So this guy comes in one day, and he is not a lawyer, and he's an acting coach, and he's wonderful. And he says, I just want you to practice your argument. And I grab my legal pad, and he says, no, give me your argument. Look at me. Don't look at your legal pad. And so I did. And then he says, no, I want you to practice it holding my hand. Practice your argument holding my hand. I was like, this is really weird. And but the truth is, it really did help. He understood that what appellate advocacy is, particularly at the Supreme Court, is it's really intimate. I mean, you're just a few feet away from the Chief Justice. If you're sweating, they see you, and it's a conversation. And if you're looking down at your legal pad the whole time, you're not going to have that conversation. And he really helped me see that and break through and understand that. And that is something that I have tried as an advocate, but also as a teacher, to really emphasize to my students that it's kind of, can you have a conversation with someone? You don't have to sound like a lawyer and be argumentative. That's the way to persuade someone, not, and to try and help the court in its search for truth. So, I do think that Supreme Court advocacy is a specialized skill, and it should be left to people who understand the court. That doesn't mean that a first-timer can't do a good job. I'd like to think that in Hamdan versus Rumsfeld I did, and of course everyone has to have a first time. My partner Dom Perella had his first time just a few months ago and gave a bang-up, awesome argument. Why? Because he understood how the court operates. He didn't just waltz in and say, "Hey, I got this," because I was the guy at trial. That wasn't it. It's because he really deeply watched a ton of Supreme Court arguments, had already written a ton of Supreme Court briefs. I had absolute confidence that someone like that could come in and do a great job, and he did. So I think that two things about the Supreme Court that make it different are, one, precedent doesn't bind the court. So in every other court, in federal courts of appeals, I and others are standing up arguing, well, the Supreme Court has said X, or this court has already said Y, and that's it. That's the game over. That's the whole thing. At the Supreme Court, you say that, and they're like, okay, but why should maybe we said it, but why should the rule be X? And that's what all the hypotheticals are getting at, and so on. It's a whole different profession, actually, at the Supreme Court than it is in ordinary appellate advocacy. And so if you're used to that, if you've seen it a lot, if you've written briefs that are geared to that, you're going to naturally be better than someone who isn't. So that's one thing. The other is just the physical dynamics of the courtroom, which make it really so intimate. And because it is that kind of, you're just a few feet away from all the justices, those folks who have a more kind of bombastic or argumentative style, I think, don't do as well as those who have a conversational style. And it's really, I think, important to see a lot of arguments before one argues in the Supreme Court. I mean, I'm fortunate to be helping run the practice that Chief Justice Roberts ran at Hogan Lovells when he was a private lawyer. And one of the things that he emphasized time and again was, it's not really about the counsel, it's about the justices, and they're having a conversation with one another. And we as the counsel can help guide that conversation, can make the strongest points on one side or the other. But ultimately, you have to realize that when you're arguing at that court, unlike virtually any other court with which I'm familiar, it's you're a facilitator more than you are kind of a arguer. So my oral argument preparation is pretty much now down to a science, since I've done 24 arguments and 22 of them have been in the last 6 years. So I've pretty much got this down. I don't know if I'm any good at it, but at least I got an attack plan. So basically, a few weeks before the argument, I'll read all the briefs and take very, very careful notes on them, type them all up. And then from there, I'll break down those notes into a long outline, kind of the way a legal course outline would work, with topical breakdowns by subject matter. And I'll make essentially a binder. And then a few days before my first moot, I will create almost a cheat sheet, a one-pager, that has all of my points for each major set of questions on it. And I'll just be constantly revising that binder and my cheat sheet. And the binder I bring up with me, I'm not as good as, Tom or Paul or someone like that who doesn't bring up anything. I always got my binder. I haven't had to look at it except once when it was a very technical question, but I like having it up there. The majority of my argument prep is done in the moots. I'm a firm believer in moots. I did 15 moots before my very first argument in Hamdan. I still will do as many as 6 or 7 in a big case. And it's also a part, I believe in that in 2 ways. One is it really helps me get familiar with the case, and I've hired, the best team of Supreme Court people around, so much so that I think in my 10 or so arguments at Hogan, whatever they've been, I don't think I've gotten a question at the Supreme Court that I haven't gotten already at my Hogan moots. The people there are that good. So one thing is that. So that's preparing me. But the other side of the moots is it's a way for the clients to really make sure that they're comfortable with my answers. Because I might know the legal answer to something, but oftentimes there are business implications, there are personal implications, all sorts of things. And if you have a bunch of moots, you're more likely to ferret out all of those kinds of questions and make sure that you as an advocate are saying the right thing. I mean, that's particularly true in my practice because we specialize really in cases in which there's a lot of other law firms involved and a lot of other clients involved. So, for example, I just argued earlier this month the natural gas case, the preemption case at the Supreme Court, which had 10 different energy clients, 10 different law firms. It's really important when you have that number of people to make sure that they all have heard your answers to a wide smattering of questions to make sure there isn't any divergence among the client group. And that's just a natural facet of kind of litigation involving multiple players. So I'm a big believer that the briefs are the most important piece. I know that the oral advocate always gets a certain amount of the sizzle and flash, but at the end of the day, it's how well that legal brief is crafted. And for me, in my hiring decisions over who I'm going to hire, I probably spend more time thinking about that. Who's a great writer, but not just a great writer, who's analytic? Who's got that kind of power to really understand what the case is about, what the tensions are in the case law, and so on. And so, I spend a fair amount of time on the front end when we're filing briefs, making sure that they're crafted in the right way. Because if the brief's done well, then the oral argument is going to go a lot easier than otherwise. And every so often I'll pick up a case that's been briefed already, and that sometimes can be challenging. So I have a couple of expectations when I go into the court. One is, unlike I think a lot of other people, I don't view any justice usually as out of bounds. That is, I think it's really important when we brief a case and when we argue it that every justice is seen as in play. That is, look, of course certain justices have different views, but I do think a lot of litigants have a defeatist attitude about this and don't understand that the justices are really are trying to do the right thing. They obviously have past positions, but your job as the advocate is to talk to them in light of those past positions. I mean, one very good example was Lewis versus City of Chicago, which was a disparate impact case that I had on behalf of 20,000 firefighters and applying for firefighting in Chicago. A lot of people thought there's no way the court's going to accept this and so on. 9-0 opinion written by Justice Scalia affirming this class action disparate impact in 2010. Hamdan versus Rumsfeld, another example, but there's so many in which I feel like oftentimes lawyers, interest groups, and the like abandon justices who otherwise might be in place. So that's one expectation. The other expectation, is that I'm going to get a question really fast. I'm going to draw one. And a couple of times I haven't had that. So I normally have like one line written down on my legal pad, and I can ad-lib for a little longer. But a couple of times, including in a big case, Ashcroft versus Al Kidd, in which I was defending former Attorney General Ashcroft for allegedly abusing people's civil liberties in the War on Terror, I didn't draw a question for a while. And that was a little bit unnerving. I was looking at the courts and who's going to ask me a question, and I remember a couple of them grinning back at me, but didn't get a question, but finally did. But it is a very questioning court. That's what makes it so exciting. And I should say, unlike other parts of American government, this court works so well. I mean, these are 9 extraordinarily talented people. They're working super hard. They're analytic, they're powerful, they're rhetorically gifted. it's a real privilege and an honor to walk in there and help facilitate a conversation among them. So, I mean, in part because of the tradition of this firm and Chief Justice Roberts running our practice and the way he ran it, I think everyone here really believes very deeply our job is very simple, which is to provide a straight answer to the question and to be as forthright as we can with the court. That means acknowledging our weaknesses, acknowledging the strength of the other side's arguments, not using rhetoric to kind of paper it over. Obviously, we have a job to do, which is to win our case for the client, and we take that extremely seriously. But that's always done against the backdrop of what the court expects from us, and it's a real honor to walk into the court and to try and fulfill that mission as best we can. So I don't walk in with an argument tree or anything like that. I can't imagine that plan working. Instead, I recognize that there are 9 justices there who may have very well 9 different lines of questions that they want to ask me, and indeed all at the same time. And so you can flicker back from one line of questioning to another because you have so many people on the bench and because they're all so good and dedicated. And so it's natural to have that kind of cacophony of different questions and different perspectives happening. And so instead of walking in with an argument tree, I walk in with 2 points that I have at the top of my pad, which are the 2 things I want to leave the court with at the end of the day. Hopefully to try and get to them, to try and signal to the court, I got something important here. It's not just a line-by-line debater's argument, but this is the important point. This is the theme. And to try and structure a theme that questions that I'm getting, even if they're from disparate sides of the court and whole different areas of questioning, still somehow my answers yield back and come to some common theme. I guess that's what I'd say. It's obviously a difficult thing to do. And you never want to be the person trying to drive the conversation, I think, at the court too much, because after all, your job is really to answer their questions, not to give a speech. So I certainly don't think my job is just to be the counselor to the court in the sense of a law clerk or something like that, just giving, the most unvarnished, straight answer, which has no client goal behind it. Obviously, you're a lawyer for the client, so you have to, at the same time as being totally straight with the court, also make the best argument on behalf of your client as you can. And yes, you're going to get questions from a variety of different angles on the court, and your job is to figure out, before you walked in, what's your best answer to those questions, and B, try and weave those into the questions that you're getting. Well, it's hard as the advocate to know the importance of oral argument, because obviously that's a black box and we're not seeing it. I certainly think it's absolutely the case that people lose cases at oral argument all the time. They concede the wrong thing. They don't have a theory of the case. They don't have a rule that's clear for the court to understand. All sorts of things like that I've seen happen time and time again. I mean, I think I watched almost every argument at the Supreme Court from 2009 to 2011 because running the Solicitor General's office and being the principal deputy before that, that's what you do. And lots and lots of times you see people losing cases. In terms of winning time, I do feel like that happens too. It's a harder thing to test, and obviously the law clerks and the justices know it, but we as the outsiders don't. But my sense is that, yes, sometimes people come in and they explain why a position that a lot of people think might be unreasonable actually is reasonable. And it's not, again, rhetoric or something like that. It's actually that the position's really good and a lot better sometimes than the briefs have acknowledged. I've certainly had senses in both directions at oral argument, whether something is going well or not. I think, probably the one that sticks out the most in my mind is the very first argument in Hamdan versus Rumsfeld, in which, I was arguing against Paul Clement. It was probably his 35th argument. Such a beautiful advocate, it's just amazing. But I think his client had directed him to take a really hard-line position, so much so that Justice Souter got really, really angry at him, and Justice Souter, not someone to really flash his anger, but it was extraordinary moment. And it was a moment in which I remember my co-counsel looked at me and said, "We just won the case." And I think in some ways that's right. Again, it had nothing to do with Paul. It had to do with the fact that the administration at the time directed him to take a really ideologically aggressive position. And I guess one of the things, it's about Supreme Court advocacy, but about government service more generally, is when there are a bunch of ideologues on both sides of every issue, and in general, those positions don't fare well at the Supreme Court. I mean, and don't fare well in practice. I mean, Guantanamo, these military trials, they've never happened. Been more than a decade since, and nothing's happened. They've never gotten off the ground. And so when you have kind of extreme ideological positions, and then you're trying to advocate for them in the Supreme Court, that's a tough position to be in. Well, so your job as the advocate is always to win for your client, okay? So that's why you're doing it. So, with Mr. Hamdan, he was freed very soon afterwards and is living in Yemen and so on. But there was enormous practical impact to that decision. The court said that Common Article 3, the Geneva Conventions, were bound the United States and required essentially the rights indispensable to all civilized peoples to be given to our detainees across the globe. And that changed our torture policy. It ended ghost prisons. There were a lot of things that happened as a result of the Supreme Court's decision in Hamdan. But again, your job is always, as the advocate, not to think about that, but to think about the person who you're representing. And that's true in every case. Obviously, when you're representing the government, it's a different matter when you're in the Solicitor General's office, because the client is the United States. It's not one agency. It's not the White House. It's not the Congress. It's everyone. That's an abstract entity, and so it's different. That entity can't sit in the courtroom and criticize you if they don't like your answer, because there isn't that one entity. But that's what makes the Solicitor General's office so interesting. And kind of, the White House may want you to do a certain thing, the Congress may want you to do another, the agencies a third. It's an enormously interesting position. I remember, the hardest, maybe one of the hardest calls I made was the position to take on whether to patent the human genome. There were so many different positions among the agencies. In that case, the Patent and Trademark Office had issued about 20,000 patents on genes since the Reagan administration. I, as a failed pre-med person, was scared to really get into the gene stuff, but ultimately knew I had to. So I used to go to the NIH on Monday nights and get tutored in genetics and to try and really understand the background of the decision. I wanted to understand the economics of gene patenting. Larry Summers at the White House helped me think that through and had me talk to some experts. It was really, really an amazing constellation of people who were helping me. But at the end of the day, I had to make a decision. Do we seek the invalidation of all these patents? And ultimately I did. It was a position that at the time I got a lot of criticism for, and people said there was no chance that the invalidation would be successful. But again, this is a good example of how if you don't approach things ideologically, but you approach things saying every justice is possibly receptive to your argument, let's figure it out. 9 justices unanimously concluded that human genes can't be patented in the Myriad case. And so it's a good example of trying to walk into court and say, I'm going to talk to every justice, not just the 5 whom I think are friendly. Patent law is a really interesting example because it's one of the rare parts of the American system in which we actually have a specialized appellate court that deals with patents, and many of the people on the federal circuit have PhDs in various fields of science, not in kind of German philosophy, but in biochemistry or things like that. So when you're arguing in the federal circuit, and I've had some enormously complicated technical cases there, boy, I am going to spend a long, long time understanding all of that science because those judges understand the science. And so there's going to be a bunch of questions that come from that. By contrast, when you're arguing a patent case at the Supreme Court, I think the name of the game is to keep it at a more general level, and in particular to explain why what the Federal Circuit is doing is out of line with the way that standard legal principles are. And if a case is framed that way, it's usually successful because the Federal Circuit, I think, has developed a lot of what look like very patent-specific or Federal Circuit-specific guidelines and rules that the U.S. Supreme Court, I think, sometimes bristles at. And so we've seen the U.S. Supreme Court time and again overrule the Federal Circuit. I just did one in a case called Highmark about attorney's fees and whether or not you could essentially sanction someone for bringing a frivolous case. The Supreme Court looked at it and said, hey, we should apply the same rules here as we do in all the other attorney's fees disputes. There's nothing unique about patent law. There's nothing unique about the Federal Circuit. We should apply the same rules. And so that kind of thinking happens time and again. At the same time, I do think this is a court that is more interested in patents than in any court in our lifetimes. This is a court that understands that the future of the American economy is moving in the direction of intellectual property. We're producing fewer and fewer manufacturing jobs and things, and we're producing a lot more IP. And I think there is a concern reflected in the high number of patent cases that the court has heard that they want to make sure that that we're getting the system done right. So with respect to kind of the expertise and technology, I guess I have two thoughts. One is you as the advocate better be darn familiar with the technology, whatever it is. I mean, I just argued the Hargis case in December, which has to do with screws and metal fasteners. But darn it, I spent a long time holding those screws in my hand, understanding how they worked and so on, even though at the end of the day it was a trademark case about issue preclusion. But the court may ask you some questions about it and you have to know. From the standpoint of the court, however, I do think that this gets a lot overblown with some, media reporting, oh, the justice doesn't understand cable TV or this or that. I was involved in the Aereo case in which I know there's a lot of hoopla about that. Look, these folks are 9 really, really smart people. I guarantee you they can understand the technology if they think that's relevant to the decision. Oftentimes, the decision isn't turning on the technology, it's rather turning on something else, some standard legal principle. And to the extent it is turning on the technology, I do think this is a court that's adopted a fairly minimalist, go it slow approach because they don't want to stymie the development of new technologies. Well, the Supreme Court grants cases not because of the individual facts, almost always. There are obviously some exceptions. The death penalty cases that are, currently before the court, or, Bush versus Gore, or other extraordinary cases, in which the facts actually matter. But oftentimes, the court's trying to understand what the legal principle should be for the country at large. And they know that, whether one case has sympathetic facts or not, another one might not. And so they got to make the right decision on the law and be cognizant of the old aphorism that hard cases make bad law. So in general, I think the fact that you see some justices who aren't as steeped in the nitty-gritty technical details of a particular technology as it comes to the court, I think just reflects the fact that that's not really what the case is about. The case is about a broader set of principles. And if you as the advocate come in and just want to talk about the facts of your case, you will be run out of that courtroom really quickly. Well, working in the Solicitor General's office was undoubtedly the professional highlight of my career. And in part, it's because you're walking in and you're walking into an office that has enormously talented, hardworking, respected people in there, people who are always trying to do the right thing. There's not politics in that office, and it's breathtaking. And every single day I felt like, oh my God, how am I going to do my job in front of these people, because they're so much better than I am. And that's true at the line level, and it's true at the deputy level. So it's an enormously talented constellation of people in that office. In private practice, I've tried, quite honestly, to create my own mini SG's office. And my hiring decision, I spend more time on hiring than anything else. And my hiring decisions are informed by the fact that I did the hiring process there in the Solicitor General's office for a few years. And so I kind of know how to do it. And I've basically adopted the reverse of the Court of Appeals judges, who are always clamoring to get students so early that they're like in their first year of law school sometimes when they're snapped up by one of the so-called feeder judges on the DC circuit or something like that. I do the exact reverse. I wait until people are far along in their clerkships. I want to hear what their judges and justices think of them. I want to hear what their peers think of them. I want to hear what their summer job folks thought of them. And I'm not just trying to hire the very best lawyers and analysts. I'm also trying to hire the very best people, the nicest people, the people who are good to work with, because 100% of my work is with other firms, and I want to make sure that that is done, that people are really happy when they work with us. And so I do have a kind of SG hiring model approach here, and it's worked. So in the SG's office, I rarely got a question at the real Supreme Court that I didn't get in one of the moots, and the very same thing is true here at Hogan. Have not gotten many questions, if any, that at the real Supreme Court that it hasn't been asked in one way or another by someone at one of my moots. When you're a principal deputy SG or acting SG, it's a totally unpredictable smorgasbord of things. You have very little time to actually prepare for the arguments. You really have only the weekends to prepare. That's your weekend job. Your daily job is really hard questions about what cases to appeal, because every appeal by the United States in the 50 states has to be authorized by the Solicitor General. So any kind of, procedural appeal in, New Orleans from the district court to the circuit court has to be authorized and things like that. So that's a lot of time. There's a lot of management stuff, and then there's a lot of advice that you're giving the Justice Department more generally about complicated issues of law. And so it's a whole bunch of things, but when you look at an SG and you see them in the Supreme Court and you think that's their job, no, that's about 3% of the job. It's a visible 3%, obviously, and it's an exciting 3%, but it's a very small piece of the job. Well, I was acting Solicitor General, which meant that I was not nominated or confirmed. Elena Kagan had been nominated in May of 2010, and so I ran that office on that basis. The good and bad news about acting is you got to do everything that the Solicitor General does. It was an enormous privilege to do so. I was really lucky to have that. So the SG's office has a really kind of long-established tradition of formalized decision-making. That means that written memos, are prepared in every case by every agency and every component of the Justice Department that has an interest in the case. And you get all these memos, and by the way, they have to email them to each other. So they're all reading everything. There isn't like some secret memo that only the SG reads or something like that. Everything is shared among everyone. And then there's often long government meetings in which the memos are discussed and debated and the like. And that has impacted me greatly in watching that decision-making process. The forcing someone to formalize their views in writing crystallizes the discussion, makes it so much better than when you have people coming in without a memo, just kind of going off in their own directions. And so it's an enormously valuable part of the process. And Ed Needler, who's the longest serving career deputy there, is a big champion of the process, a guardian of the process. I've learned more from watching Ed Needler be a lawyer than from anyone else ever. He is just such a decent and honorable and smart and astute advocate. And it was just the privilege of my life to work alongside him and the other folks in the office. So, you walk into the meeting very highly prepared. So you've read all of the different memos. You've got a list of questions, and you're asking the questions. And you're, in many ways, like a judge. You're trying to sit there, ask the questions of both sides, sometimes there are many different perspectives, and trying to figure out what's the right thing to do. But at the end of the day, when you're running the Solicitor General's office, that's a decision you've got to make, and sometimes it's enormously difficult. It is a really heart-wrenching thing, and you agonize about it, as you should, because ultimately the stakes can be extremely high. And the job is not just to win a case. The job is to do the right thing. So, for example, when the Affordable Care Act litigation was going through and the Justice Department and the trial courts had made decisions to push standing and ripeness and all sorts of procedural objections, a lot of people said, we got to do that. We're litigators. Our job is to win cases. But no, the real job was to do the right thing for the country and to resolve that issue. And if there was a good argument, a good faith argument, not a kind of debater's trick argument, that all of these procedural defenses should be dropped and the country should have resolution of this really important decision, that's the thing you do. And so you make that call. And some people can't understand it because they say, no, you're going to help us lose the case. No, you're going to help the country reach the right decision. You're going to try your best to win, but ultimately you think getting a decision is more important than trying to delay the day of reckoning. Well, I think that the Solicitor General's office has a unique position of trust and responsibility with the court. And I think that the court views private advocates as being a little more hired guns. I think there's a group of us that practice regularly before that in which the court expects more from us than simply to be hired guns. So for example, I often have clients who say, please file the cert petition. I'll throw hundreds of thousands of dollars at you ultimately to file the cert petition. But you look at it and you say, there is nothing there. And yes, do I like making hundreds of thousands of dollars for my law firm? Absolutely. But the answer to that question has to be no, because I've got a relationship with the court and I want them to, understand that we're their partners. Obviously, we're private counsel, so we're not government counsel, but we are. Now, obviously, there are exceptions to that. You're representing a criminal defendant pro bono. They want to file a cert petition. That's a different matter. But if you have a company coming to you and they are often willing to do extraordinary things to get you to file that cert petition, you have to do the right thing. Well, I think it's the notion that the court is captured by a small group of Supreme Court advocates, I think, is a little bit bizarre. We're all so different from one another. We're friendly to one another, but we give each other a really hard time. And the thing about the Supreme Court is you always got one of those people, one of the people in the bar who's willing to do the case on the cheap. And so it's not as if people are going to the Supreme Court unrepresented. In every case in which you see a bad advocate at the Supreme Court, I guarantee you someone very experienced and someone very capable called that lawyer and said, hey, I'll do this case for free. So at the Supreme Court, I don't worry that certain people are being unrepresented or certain classes of folks. I do certainly have that worry at the lower courts all the time. Sure. So I was a law clerk in the 1996 term, which had a lot of constitutional issues, and I was fortunate to clerk for Justice Breyer. Remarkable individual, so quick, so fast, and your mind had to keep up with him, and that was a hard thing to do. But I loved it, and I loved, not just experience of working with him, but working with my co-clerks and the other clerks in the building. I think that whole set of experiences is really something to be treasured. Now, many of those justices have left the court at this point in time. And so, I've been fortunate. I worked for the Chief Justice here at Hogan Lovells and worked for Elena Kagan as her deputy. And now those are more recent experiences that I do use as I think about kind of what the justices are like and how receptive they are to a particular argument. Having spent a lot of time with them does, help a little bit. I'm not going to say it gives me any sort of special advantage, but at the end of the day, one of the things I'm constantly asking is how are each of the 9 justices going to think about this case, not from the lens of what everyone says and, an ideological filter, but really down deep, what are the kind of questions that they're going to ask? Well, I do think practically, yes, it's really important to walk into that court and understand the way each justice thinks and to do so in a way that you haven't approached this from some ideological filter or echo chamber, but really from reading their opinions, studying everything you know about them, and bringing it to bear. And we do that. Every single justice, I'm sitting there thinking, what are the points in my favor that I can use with every single one of them? What are the things that they're most going to hate about my client's case? And how do I try and accommodate that tension? So I joined the Georgetown faculty in 1997. I think I got tenure in 2001, and it's a great, great privilege to teach there and have students, a lot of students. My classes are big. I think the most important thing is, unfortunately, the legal academy today, law schools today, have gotten so theoretical. And certainly there's a role for it, but that there aren't very many of us practicing lawyers teaching in the law schools today. And that's why my classes are so oversubscribed, I think. It's not because I'm a particularly good teacher. I hope I am, but I'm not sure that that's it. It's because there are people yearning to actually know how to be a lawyer. And law schools are really good today, particularly the top law schools, at teaching 18th century German philosophy, not so good at teaching people what really the nitty-gritty of being a lawyer is about, how it works, and how that practical experience can influence both the theoretical side of teaching, theoretical side of scholarship, as well as the practicalities of teaching. And to me, that's the most fulfilling part of my job. And so, for example, I've been talking a lot today about how you approach things in a non-ideological way. If you teach that way, too, if you're really trying to see both sides of an issue and put it forth, that really opens up doors to students who otherwise would see things in a more monolithic fashion. And I view that as kind of my duty as a teacher to really bring that out. And so sometimes my evaluations say, guy's too conservative. Sometimes they say, guy's too liberal. And it's a really funny thing, but your job is really not to be either of those, but your job is, in many ways, just like to be an advocate, is to really see both sides of an issue and to forward the discussion. Yeah, so certainly sometimes when I'm doing a big case, my students have expectations that I have a certain view, and boy, they're a little, I try and encourage them to say the other thing, but sometimes it's hard. So sometimes I brought people in. So during the Affordable Care Act, when I was teaching constitutional law, and I had litigated and argued the case in all the courts of appeals, I brought in Paul Clement, who had just argued it in the Supreme Court, because I wanted to make sure I couldn't really pierce that fully. I mean, I knew that the students were going to be worried about that. So my obligation at that point to my students was bring someone in on the other side. And I try and do that with regularity to try and make sure that they feel like they've had a good balanced discussion of a really hard issue. Well, I've been on both sides of this cameras issue. I mean, I understand the justices and both their security concerns and their concerns that arguments are going to get spliced up and misrepresented and so on. But look, at the end of the day, this is the people's court, and there are 400 seats in that courtroom. I often can't get a seat in a hot button case, and certainly the majority of the American public can't. It's one thing if they're just deciding issues of bankruptcy law or something like that, but when they are discussing and deciding the most momentous questions of the day, be it abortion or the death penalty or gay marriage or whatever, I think that my personal view is that that court should be open and viewed by the American public at large.